and Mr. Cole as well, members who I've spent many hours in this room with. You know, the chairman made a statement about my friend here, Mr. Raskin, and he is a fine attorney, and it's been amazing to me throughout this year how the Judiciary Committee has sidelined fine attorneys like himself into not asking questions and to not being a part of the process. It's been really interesting to watch because he's actually a good one. And as you said, he's a good constitutional attorney. I'm not a constitutional attorney. I'm a pastor and an attorney from North Georgia. But I believe that you take another look at this and you can apply constitutional lenses. We all sat through those classes, but it's a common sense lens. It's a common sense lens. Mr. Cole made a comment when in his opening statements. He says, you said, Mr. Cole, it said it doesn't make sense. Yeah, it does. It makes perfect sense. Look at the pattern. You know, the only thing that is a clear and present danger right now in this room is the pattern of attack and abuse of rules and decisions to get at this president that started over 3 years ago, really the night he was elected. And I said the other day in the committee hearing, I talked about, you know, having the means and the motive and the opportunity. The opportunity for this day occurred last November when we lost the majority. It occurred. Because they'd already talked about it for years in prior. And so now we just bring it forward. And we've tried a lot of different things to get there. And we'll talk about that, I'm sure, as the time goes on today. And look, we can have plenty of time to talk about the articles and the very vague articles that we did. It's pretty interesting if you read the report from the majority. There's a lot of discussion about crimes, but they couldn't find it in themselves to charge one. Again, common sense. Articles, and when you think about impeachment, you're thinking about impeaching a president in particular for crimes. You're thinking about it, you're sitting it down. It was, and this majority has tried so hard to be like Clinton and Nixon and failed so miserably. But every time we try once again, except the one thing, when it came down to the very end, the one thing they couldn't do is actually find a crime. They talk about it a bunch. If you read the majority's report, it is well written. It is some of the best work you'll see, frankly, in some ways, of fictional accounts of what this actually is, but it actually talks about it. That the problem here is a majority bent on finding something for this president. So, Mr. Cole, it's not a surprise. In fact, it's a sad day, for not only for the Rules Committee, but for the Judiciary Committee. You know, it's telling that the articles of impeachment, to show you how partisan this is, and really the concerning part that I see, and Mr. McGovern is a friend, and we disagree, and you're exactly right. We disagree probably on a lot of things. Is this glass half full, half empty? And that's fine. That's what we're supposed to do. That's what our voters send us here for. But to find ways to actually work, well, we have worked together. The question I have here, though, is if this was, as the Speaker said, should be overwhelming, bipartisan, and the American people understand it, then why are we in the Rules Committee today? When it was with Clinton, it was a UC straight to the floor. It didn't have to come to the Rules Committee because both sides could see there was something needed to be discussed, and that's not true here. And so we're having to bring it up here to the Rules Committee, a place that I have spent many hours, and many of us on this group have discussed many things, but this should not be one of them. You know, it's interesting that I hear a lot today, and I've heard already from Mr. Raskin and from the chairman as well, the discussion of the founders. And it's interesting, we cherry pick the founders, and that's okay. That's what, you know, partisans do. When you're in a partisan impeachment, you cherry pick the founders. If you like this partisan work, you do that one. If you like the other partisan. But the one that's not mentioned is the very thing that we're here for. And that was found, I believe it was in Federalist, I think it was 65. It was Hamilton. When he said this, he said the founders warned against a vague, open-ended charge because it could be applied in a partisan fashion by the majority of the House of Representatives against an opposition president. Alexander Hamilton called partisan impeachment regulated by more of the comparative strength of parties than the real demonstration of innocence or guilt, the greatest danger. And additionally, the founders explicitly excluded the term maladministration from the impeachment clause because they did not want the subject presidents to the whims of Congress, their words. James Madison said, so vague a term will be the equivalent to a tenure during the pleasure of the Senate. And I would say it would be a tenure to the pleasure of this House. When we understand what's going on here, when we look at the discussions here, there are many things that I want to talk about, but the first I want to do is when we talk about how we get to a certain place, proper process leads to proper results, and we've not had any of that in this process. I have always said, and I've said it many times, in our discussions lately is that this is all about a clock and a calendar. It has been for a while. Since January when we were sworn in, it's about a clock and a calendar. Why do I say that? Because we had to get to it by the end of the year, because if we went into the next year, it would be really too close, especially from the House's perspective, to the elections that they're trying to interfere with. And yes, they're trying to interfere with elections, the 2020 election, by actually beginning this process and been going forward. Now, the conduct is not conducted that respects the American people. The clock and the calendar know no masters except themselves. You see, our committee held its first hearing on December 4th, literally the day after Schiff publicly released his report. In the first minutes of the hearing, Mr. Sensenbrenner furnished the chairman with our demand for a minority day of hearings. The chairman also set a deadline of December 6th for Republicans and the president to request additional witnesses. But it wasn't until Saturday, the day after the deadline, that Chairman Schiff transmitted 8,000 pages of material to the Judiciary Committee. And we still haven't gotten everything, not that it matters to the majority. For institutionalists, this should bother you. You can still go ahead and vote for your yes tomorrow and vote for yes today and do that, but it should matter for this institution that while I was in Georgia, I received a call from my staff saying they've just released 8,000 documents, some drives, some of which were going to be kept in a secure holding. And when I asked the chairman about these documents, where are they going to be used, he said, well, we're not going to read them either. We're not going to have a chance to go through them. We're just going to go ahead with what we're doing. That was from my chairman, who I respect greatly. We've done a lot of things together, but it has been very difficult when in a hearing of this magnitude, how can anyone, Republican or Democrat, actually go back and look at their constituents in the face and say, we looked at all the evidence. I looked at everything and I came to this conclusion. No, we cherry-picked the evidence and we only used what we wanted to do, because that material, which by the way is still not all been released, there's the Inspector General IG report that is still transparent, has not been released. Now, whether it's good or bad is irrelevant. But when you're talking about impeaching a president, shouldn't the underlying evidence sent to Judiciary Committee actually matter? Again, it doesn't take constitutional experts coming in and telling us about it. It takes common sense to know that you don't impeach somebody without at least making all the evidence proper. But you know, that's what happens when you're to the tyranny of a clock and a calendar. When you're the tyranny of a clock and a calendar, nothing else matters. It's like what's going to happen here in the holidays is you're getting close to that day and you're supposed to give that gift. Nothing else matters. You just got to go get it. And it's the last minute. If you don't have anything, Mr. Hayes, I bet you've done this. You go out and you just buy the first thing you get. And this is what was happening. The clock was running out, so they found a phone call they didn't like. They didn't like this administration. They didn't like what the president did. They tried to make up claims of that there was pressure and all these other things that they've so outlined in the report. But at the end of the day, it's simply last-minute Christmas shopping. They ran and found something. They said, we can do it, but no crimes. None in the articles. Abuse of power, in which any member can make up anything they want to and call it an abuse of power. But in the report, they document bribery and extortion and all these other things, which they can't put into the articles. And then the obstruction of justice. Again, it's sort of interesting when I just read Chairman Schiff transferred on a Saturday 8,000 pages of what we were supposed to be working at for the next hearing. We submitted our list of witnesses to Nadler the day before, Mr. Nadler, before the Schiff sent us, we submitted it before Schiff had sent us any more evidence. Last Monday, we had a hearing so Schiff's staff and Nadler's consultants could tell us that the president needs to be impeached. Again, nothing from Chairman Schiff, who had made the reference to himself being like Ken Starr. But for those in this room who have at least opened a history book, Ken Starr actually came and testified and took questions from everyone, including the White House counsel. On Monday, the chairman rejected all of our witnesses out of hand. And on Tuesday, the morning after the presentation of articles were unveiled. Remember, think about this. No factual-based witnesses. We had a bunch of law professors, one for us. By the way, I did ask for another one. Didn't get it. No reasoning. We just went back, and we were in impeachment hearings, and we went back to the normal 3-1 ratio. I asked for one more and basically didn't get it. It was an interesting conversation between the chairman and I. Didn't get it. Then we came in and got our witness list summarily dismissed. We get information dumped to us in the middle of what we're supposed to be doing, right before we're having to have hearings, before we had to, after the fact, we had to turn in our witness list. Judge, I don't think this would fly in any regular, normal court proceeding, because I know this is not. So before anybody wants to tweet or say anything, we're not in a court. I know that. We're in a kangaroo court, it feels like, in this place. Because all of this is backwards. What's up is down and down is up. We're more Alice in Wonderland than we are House of Representatives. Because whether you agree that he needs to be impeached or not, do you not think there needs to be a modicum of process and rights? All of this is true. The rules completely aside, the minority hearing day, broken. Access to committee records rule, broken. Due process rights for the accused in impeachment, completely out the window. Rules for decorum in debate, well, we've seen that broken even on the House floor. Res 660, the authorization for this whole thing, the chairman could have used it to run a fair process. Unfortunately, we didn't. The problem comes down today is there's several things that I'm going to leave you with, Mr. Chairman. And this is it. After all that has been said, all that's been talked about, and all that is within that wonderfully written report, there's 4 facts that will never change. Both the President and Mr. Zelensky say there was no pressure. The call transcript shows no conditionality in aid and an investigation. By the way, Mr. Sondland, their key witness, the only thing they ever quote is his opening statement. They don't like to quote when he actually was questioned, when he said, well, yeah, I presume that. And then when he talked about Mr. Yarmuk said, we didn't have any conversation about conditionality of aid. That was just come out just the other day. I'm not sure where we're getting this, but it's definitely wasn't the call transcript. Ukrainians were not aware the aid was withheld even when the president spoke, and Ukrainians did not open investigations, didn't get a meeting, and still got their aid. But what did we see last week and over the past 2 weeks? We saw Mr. Zelensky, President Zelensky, pillared in our committee. He's either a liar, a pathological liar according to the majority, or he is so weak he shouldn't be governing that country. That's tragic. We actually did that to this sitting leader, world leader in our committee. These are the kind of things that bother many of us. But also, I know this is also on a clock and a calendar, too. We'll have a few hours here. We'll talk about it. But I will remind my majority friends, and I do consider you friends, the clock and the calendar are terrible masters, and they lead to awful results. And yes, there will be a day of reckoning. The calendar and the clock will continue. But what you do here and how we have trashed the process in getting here will live on. And it will affect everything that we've come for. And so whatever you may gain will be short-lived, because the clock and the calendar also recognize common sense, which has not been used in this proceeding. And with that, Mr. Chairman, I yield back.